Our main news this morning, campaigners against the government's policy to send migrants to Rwanda say they'll now take their fight to the Court of Appeal tomorrow.
And that comes, of course, after the High Court said the first flight to take asylum seekers from the UK to Rwanda is currently set for departure on Tuesday.
Well, let's talk through some of the legal proceedings and all of this. Immigration lawyer Skylar McKeith joins us now. Skylar, morning to you. Look, the fact that the High Court said on Friday that this was a legal thing to do, but what grounds are there for appeal?
Yeah, so the question on everyone's mind is this arrangement legal? And at the moment, it really remains to be seen. Currently, under the immigration rules, an applicant whose asylum application is treated as inadmissible may be removed to a safe third country. And where an application may be treated as inadmissible can be for a number of reasons, including where an applicant passes through a safe third country and fails to make an application there. And until now, the UK has not had arrangements in place with other countries to remove those asylum seekers. It could only remove individuals in more limited circumstances, such as when an individual has refugee status in a safe third country. And what the Borders Bill would allow for is the transfer to another country of an individual who has lodged an asylum claim in the UK, rather than having it be declared inadmissible. Now, the issue is that the Refugee Convention does not explicitly prevent the removal of a refugee to a safe third country. But the removal to a safe third country where a person's human rights would be violated would be unlawful. And so I'll give you an example of that. And that would be if that individual would be exposed to torture or degrading treatment. And certain organizations have pointed out that Rwanda's situation for the LGBTQ community is poor, and they anticipate that human rights concerns may come to light as a result of that. On a separate note as well, the United Nations High Commissioner for Refugees considers this arrangement to not meet the requirements necessary to be considered a lawful and appropriate bilateral transfer arrangement. And they have also considered it to contain inadequate safeguards to guarantee international protection.
It sounds very, very complex, and some of it's hypothetical as well. If they're going to try and lodge an appeal before a flight on Tuesday, can they possibly get that done in what would basically be just one day?
It's possible. The High Court judge denied the injunction to bar the first flight. And it's important to note that the court has not decided that the plan is lawful. They have decided it is acceptable for the Home Office to proceed unless and until it is found unlawful. So the judge accepted the removal to Rwanda will be onerous and granted the right of appeal against the decision. So a full judicial review is due to take place before the end of July, but it remains to be seen as to what will happen next week.
I mean, you mentioned the Rwanda not being a safe place for LGBT people. Which perhaps there's merit in that argument. But does that open a door, and I know this is a hypothetical, but does that open the door to anyone wanting to appeal this decision, just saying, well, actually, I'm LGBT, and therefore they've got a case, even though it may not be true?
I suppose that is possible, but you do have to provide proof to some extent. But yeah, I suppose it could open the door to the floodgates, but it really depends.